So this is the third time I speak here. In the past, my presentations were far more closely connected with the counterterrorism part of the work. My approach to that has been to look at the interplay between counterterrorism measures and principled humanitarian action. In the past, I spoke about the fact that one of the key ways of one of the key instruments in counterterrorism toolkits is stemming the financial flows to groups designated as terrorists. Frequently, these are groups that are parties to armed conflict, that exercise control over populations in needs. These counterterrorism measures often prohibit making this famous material support available to these groups. How does this impact humanitarian action? Because frequently humanitarians may have to provide what amounts to material support to these groups in order to operate. So that's what I've been looking at. I've also focused on that particular challenge specifically here in relation to Gaza, where Hamas is a designated group, but that's what I spoke about in the past. I'm not going to speak about it on this occasion, but let me add another element of complexity that has now hit this particular context in relation to that discourse. What became apparent recently is that, and it's obvious in terms of the legal structure, it's not just humanitarian actors that must also comply with these prohibition on making material support available directly or indirectly to designated groups. It's also private actors, such as banks. And banks, as part of their general de-risking following the financial crisis and significant fines, have suddenly realized, hold on, by providing banking services to INGOs that operate in so-called high-risk jurisdictions, so where there are designated groups, they might be indirectly providing prohibited material support and therefore violating these counterterrorism measures. I worked on this in the UK, where a number of INGOs operating in these so-called high-risk jurisdictions found their access to banking services extremely curtailed. It was difficult to carry out transactions. It was difficult to receive money and transfer it. This was in 2007. I came here in the summer of 2018 to do some of this Gaza-related work, and I asked INGOs, I was saying, oh, how's it going with your banks? And they just looked at me blankly. Well, fine, thank you. And then I came back here in December, and I said, well, how's it going with your banks? A third of them had been debanked, outright debanked. So their banks had said, thank you very much, you're too much of a risk for us. So that's, to me, it was very interesting. It's a problem that has only now reached this particular context. Not unconnected to this is the fact that as of October, I think, Israel is a member of the Financial Action Task Force, FATF, which obviously is scrutinizing what Israeli banks do a lot more closely. But here's a new dimension of this interplay between counterterrorism and humanitarian action. So on Wednesday I have a day off, I understand, Ido, and I'm going to go and speak to some of these INGOs up in Jerusalem to try and map the problem. But that's not what I'm talking about today. I don't know where the best place is for people to see me. I'm going to lean back a bit. Exactly, keep moving. So what I'm going to talk about today is something that's more closely connected to the belligerency side of the work here. And I think it's you, Ido, who have come up with the program. You seem to have spun the principle of proportionality throughout the program over the 2 weeks, and it's a principle that finds that appears in various parts of public international law in different ways. Although the basic concept is the same, we're balancing two competing interests, if we want. The way it is framed is rather different if you look at how it appears in IHL, International Humanitarian Law, how it appears in the rules regulating resort to armed force, so ad bellum, and how it appears in human rights law. And I'm going to focus exclusively on how it appears in international humanitarian law. A quick show of hands, who is familiar with IHL? Sure? Half and half. So I'm just going to put what I'm saying in some context before I enter into the details. But interestingly, what prompted this Chatham House study was twofold. First, I was invited to a big conference that the Israeli Defense Forces host every couple of years here, and told I was going to be on a panel on proportionality. And I said, well, thank you very much. Actually, I don't know anything about proportionality. Please put me on another panel. And Gillard said, what? You told the IDF to do that? You're such a civilian. And obviously they didn't move me. And there I was speaking of proportionality. And so as I prepared my presentation, I said, well, what is it I have come up with in my work? And my past work was as a legal advisor at the ICRC, at the International Committee of the Red Cross, but also as head of the Protection of Civilians section for the Office for Coordination of Humanitarian Affairs at the UN in New York. And what I would frequently have to do, particularly at OCHA, whenever there was a conflict, my comms people would come up with these beautiful graphics of numbers of civilians killed on one side, numbers of civilians killed on the other side, frequently about the hostilities here, and have lovely graphics with lots of people killed on one side, very few people killed on the other, and go, disproportionate. And I would have to make myself really unpopular and say, look, I'm completely with you that this is unacceptable, that it is very problematic, but choose a different adjective. It is not automatically disproportionate. Because what the principle of proportionality in IHL requires us to do is really quite specific. You're not counting the dead on one side and the dead on the other and then looking as to whether they're more or less equal. The principle of the rule of proportionality, and there's a reason why I emphasize it's a rule. The rule of proportionality in IHL is a key element in the body of rules regulating the conduct of hostilities, and it requires belligerents to do something quite specifically. It prohibits attacks directed against military objectives if it is that may be expected to cause incidental harm that is excessive compared to the anticipated military advantage. May be expected, so it's ex ante. It's an assessment that must be carried out before an attack, not afterwards. And what is it that we're balancing? We are balancing expected incidental harm, and I will unpack this in a moment, versus anticipated military advantage from that specific attack. That's what the principle of proportionality requires us to do. And it is something quite specific and not immediately intuitive to the broader audience. And this takes me back to the show of hands. As I sat there, I said, I think it would be really important to try and unpack some of these key elements for a broader audience, because it is a broader audience that is interested in actually looking at how hostilities are conducted. It is the media, it is researchers, it is also all the lay people that have a role in looking at compliance with the rules of IHL regulating conduct of hostilities. The various INGOs who do this, these commissions of inquiries that also are tasked to do so. And I thought, okay, it's really important to try and unpack some elements of this principle. And that's what I persuaded Chatham House to do, and we conducted a one-year process based on a series of meetings with experts to really try and look at some of these elements. So I'm going to try and bring out a few of the elements that we looked at. Then we're going to have a discussion, so it's probably more useful if you save your questions for the end, but if it's burning, do interrupt me. I have kids. I'm really good at determining whether now or it's not your turn later. So this is what the rule is. When is the rule applicable? And it's important to bear in mind, first and foremost, regrettably, that not every civilian death or injury or damage to civilian property in armed conflict is necessarily really a violation of the rule on proportionality. Nor, and this is something very important to bear in mind, is every such death, injury or damage to be assessed through the lens of the rule of proportionality. Let's not try and shoehorn everything into that, because That's not how the law is framed, and it'll get us to do really things with the rule that it is not designated to do. There are other rules that apply, and I'm coming to those in a second. But first and foremost, for the rule of proportionality to come into play, obviously we need an armed conflict. The number of conditions need to be met. First, the incidental harm that we're looking at, the harm that we're looking at must be incidental. That is, it's got to occur in the course of an attack directed against a military objective. Attacks directed against civilians or civilian objects are prohibited by other rules of IHL. And I realize I'm stating the obvious for many of you, but it's important to frame it. So it's the damage that occurs as a result of an attack against a legitimate military objective. Second, the harm must be expected to arise as a result of an attack, as this term is understood in IHL. And again, possibly counterintuitively, not every use of force or military operation in an armed conflict actually constitutes an attack. There's a distinction between the broader notion of a military operation, and within this, certain military operations actually constitute an attack. And I'd be delighted to discuss with the IHL experts in the room what the difference between the two is, because it is not clear at all. And in fact, this is something that came up in the recent report of the GEE, group of eminent experts on Syria, who applied the principle of proportionality, for example, to the application of the embargo, of the arms embargo. They were stopping a lot of goods coming in, and they said, the rule of proportionality applies to that. Really? That's an attack? Similarly, closing the airport, they thought that was something that was to be looked at through the lens of proportionality, which I say, really? So closing an airport is now an attack? So it's something quite fundamental to even open the doors to the rules of proportionality in the first place, but it is something that is by no means clear among IHL experts what constitutes an attack and what's a military operation more broadly. And then thirdly, and I'm going to come to this in a bit, only certain types of incidental harm are expressly referred to as falling within the scope of the rule: death or injury of civilians and damage to civilian objects. Again, I make myself very unpopular at times saying, yes, that's really unfortunate, it is tragic, it's something that we should try and avoid, but this kind of harm to the civilian population does not fall within the scope of the rule of proportionality. Final introductory word: we must not look at the rule of proportionality in isolation. It forms part of a framework of rules that aims to give effect to a general obligation to take constant care to spare civilians and civilians' objects. What does this include? The principle of distinction, so the prohibition on targeting, directly targeting civilians and civilian objects, prohibition on indiscriminate attacks, obligations relating to precautions in attack and defense. And the experts, should have called ourselves eminent experts, but we were just experts that met to discuss the report. At the end of it, we thought we had done something interesting here, but we also felt that the issue of precautions in attack really warranted a whole lot more attention than it has received to date, because it actually does do a lot of the heavy lifting in avoiding much of the harm to civilians. So this is kind of framing a bit the rule on proportionality. Now, what does this report cover? And am I right in thinking that you've circulated this? Yes. Okay. No, I wasn't going to say, am I right in thinking you've all read 56 pages of it, but I'm glad you've got it. Why was the study necessary? Well, I've explained why I felt it was necessary, just because there was considerable confusion as to what proportionality actually required, and I felt, from my side, that certain key elements of the incidental harm side of it had not really received sufficient attention. So that's a bit what prompted it. What does it cover? Well, initially we had intended to focus not exclusively, but significantly on the incidental harm side. But as we started working on it, we realized it was not possible to exclusively focus on this dimension, nor would it in fact be appropriate to do so. This part of the rule had to be put into context. And now that we've finished it, I actually think that possibly the more useful parts are not those that focus on incidental harm per se, but rather the parts that set out the key steps that belligerents need to take when conducting proportionality assessments, and also the final section that I'm not actually going to discuss now, that actually make recommendations for belligerents for steps that they should take to give effect to these rules when they're actually conducting hostilities. And the military personnel among the consultations were very much saying, yes, the rule itself raises challenges, but for us, what is really most difficult is integrating this into our targeting procedures. So this is very much what the report looks like. I'm giving a lecture rather than having a conversation. Is that fine, Ido?
You said to wait with comments to
Well, I'm looking at Ido. Shall we wait with comments? Yes. I'll keep going for a bit longer. So the first issue that we had to address when we actually got into the thick of this is, what is the framework for actually conducting this proportionality assessment? As I said, it is an attack. It is something that constitutes an attack. It's not a military operation more broadly. But for the purpose of proportionality, states have emphasized that it is the military advantage considered from an attack as a whole that needs to be considered, and not from isolated parts thereof. So the first thing we did was to say, okay, what does this attack as a whole actually mean? So in determining what constitutes an attack as a whole, and therefore the frame of reference for conducting this assessment, consideration needs to be given to the context in which the act is conducted. So if the military advantage anticipated from a single attack is not dependent or affected by other acts, then that constitutes the attack as a whole for proportionality assessments. But if, on the other hand, a single attack is an element in a larger operation where other acts also contribute to the military advantage, then it is the operation in its entirety that needs to be considered, the attack as a whole, for the purpose of proportionality assessments. What is, and this makes a lot more sense, again, to the military people in the room who are planning these attacks to figure out what an attack as a whole is and what is dependent on other acts of violence and what isn't. I think for the lay people, what's important to bear in mind that it is essential that the same frame of reference be used for both sides of the equation. So if you're looking at a series of acts in order to determine what your anticipated military advantage is, it is exactly that same series of acts that we need to look at in order to assess our incidental harm. Doing otherwise would render the balancing act that's at the heart of the proportionality assessment completely irrelevant. We've got to use the same frame of reference. And then the next step is, as I said, what I thought was extremely useful in this report, which is unpacking the different legal elements of this proportionality assessment. Now, the rule of proportionality sets limits to the military advantage to be considered. And the military advantage is something that we intentionally did not enter into in this report in any detail. But other than to note that the rule does set limits to it, it must be concrete and direct military advantage. We don't have any parameters for incidental harm. The rule merely provides that what must be considered is the harm that the attack may be expected to cause. Now, this brings out two closely interconnected but nonetheless distinct issues: causation and foreseeability. May be expected to cause. Can the expected harm be considered as caused by the attack? And could that harm have been expected? Was it foreseeable when the attack was planned and launched? And as I said, these are questions that need to be considered before the attack. Now, causation requires establishing a causal link between an attack and particular incidental harm. Now, if the attack is expected to be the sole cause of the harm, determining causation is extremely straightforward. So much so that in practice, the proportionality focuses exclusively on foreseeability. In such situation where the attack itself is the sole cause, the incidental harm can be considered as caused by the attack if the outcome was expected to occur from the attack in the ordinary course of events. Very, very straightforward, essentially foreseeability. Establishing causation is more complicated when there is more than one actor involved, and this could be either the opponent or some other actor that's not a party to a conflict. So, for example, an intergovernmental organization that has imposed sanctions on the country where the hostilities are being conducted. And if we set aside questions of foreseeability for now, let's assume everything is 100% foreseeable. The fact that a second actor has been involved does not automatically preclude the incidental harm from being considered as caused by the attack. And the experts developed a test. The incidental harm to be considered is that which would not occur but for the attack, so but for test, with one limitation. We do not consider harm that results from the attack of an actor other than the one conducting the attack and does not arise from the physical effects of the attack. Now this needs highlighter and pencil. Let me give you two examples. If we look at the death or injury of persons used as, keep it simple, involuntary human shields. So, people are the defending party, there's a military objective and places human shields there. Would their death or injury be something that should be considered in the proportionality assessments? It is the act of a second party that would cause their harm. Should they be considered, yes or no? Show of hands, consider them?
It depends.
Lawyer. It depends.
Yeah, it depends on the situation. Like in India, last year, military was facing the problem of stone pelters. The local people who were supporting the militants, they started throwing stones on the military personnel so that they could not continue their counterinsurgency work. So at that time, military took a person, they tied him in front of the military vehicle, just not in a human man, just in a not like animal. Just
Nicely tied him.
They kept him in front of the vehicle, and nobody threw a single stone. And because of that, many human lives saved. Because otherwise, military personnel could have used the bullets.
Right, so in a way, you're answering a different question, though. I think that whole conversation is extremely interesting. You're kind of looking at the effectiveness.
That is an intentional harm of a civilian from the direction of the one tying the person to the car. So it's not proportionality, it's the problem of this distinction, because they intentionally they took the civilians intentionally to harm it or to take the risk to harm it. So it's not a problem of proportionality, it's a problem of distinction.
That civilian are part of the stone pelters.
Were you here last year?
No.
Oh no, sorry, you seem familiar. Okay, what about the let me have a far simpler example where you've got the defending party takes involuntary human shields, places them in front of village objective. Should the risk of their death or injury be included? Yes or no? Show of hands? Yes?
Yes.
Yes. Anyone says no?
Yes.
Yes. So everyone agrees. And that's yes, that's what we say, because setting aside the fact that by doing so, the person, the defender has in fact violated its own obligations, their death or injury would arise as a result of the physical effects of the attack. Let me give you a different example. Would be an attack expected to damage a water purification facility in a country that is under sanctions and therefore cannot acquire the spare parts to fix the water purification facilities. The incidental harm that would occur, therefore, let's say the injury because and possible deaths because the water would be contaminated, is caused by the attack, even though it is amplified by the effect of sanctions. It is actually the attack itself which is causing the damage. It's not the sanctions. So this is how we have attempted to how we developed the test. Robert, you don't seem convinced. We can come back to this in a second. We can come to this in a second, but this is how we attempted to address this question of the role of the second actor. And this test is also relevant for something I'm not going to go into now, the whole question of reverberating harm, which the experts thought was just a question essentially of foreseeability and this framework for dealing with the acts of second parties. The second element that we looked at was foreseeability, and I'm going to go through this a lot more quickly because it's actually quite far more straightforward. Not only is it necessary for the incidental harm to be caused by the attack, its occurrence must also have been foreseeable at the time the attack was planned or launched. In other areas of public international law, foreseeability has been interpreted as referring to reasonable foreseeability, what should have been foreseen by the party responsible for the wrongful act at the time of the act. And the same approach also applies to the identification of harm to be considered in proportionality assessments. What can be reasonably foreseen depends on the circumstances in which the attack is planned, decided, or launched. And this includes, for example, the belligerent's capability and available resources, whether the attack was part of a pre-planned operation or occurred during dynamic targeting, and the context in which the attack actually took place. And obviously the information that an attacker has at its disposal plays a key role in what it can foresee. And this is something we go into in considerable detail in section 5, identifying the kinds of information that belligerents should try and gather in order to identify the different kinds of incidental harm. And then the third element in our analysis goes to weighing. Once we have identified our incidental harm, we have determined this is the incidental harm that may be expected to occur on the basis of this causation and foreseeability analysis, then we need to give a weight to it, which will then be balanced against the weight given to the anticipated military advantage on the other side. And assigning weight to particular harm allows belligerents to take into account a range of factors and considerations. This includes, for example, the likelihood that the harm will actually occur, because there's a difference between foreseeability and likelihood. Parents, we can foresee all kinds of awful things, but then we relax or not, depending on the likelihood that they will actually occur. No? You don't relax.
Not yet.
Okay. As you have more kids.
Yeah, I guess.
You relax. But it can take into, so the lower the likelihood, of it occurring, the less weight you will give to it. Other factors include the severity of the harm. So when we were discussing different kinds of physical harm, we said we're not going to exclude any of them, but we're actually going to give them more or less weight depending on the severity. And assigning weight is actually an important dimension of this exercise because it allows to take into account a range of factors. For example, the specific context in which an attack will take place. For example, if previous attacks have damaged water treatment facilities, any further damage is going to be more significant than if they had been intact. As far as civilian objects are concerned, greater weight should be assigned to those whose damage or destruction will have the more severe effects on civilian populations. So it really is a valuable tool in this whole proportionality assessment. So that's the third element: causation, foreseeability, and then assigning weight. Ito, how long do I have?
With discussion, we still have about 30 minutes.
And without discussion?
After you.
Okay, well, I'm just going to perhaps identify some elements. And again, this is when I make myself very unpopular and I kind of say, what is incidental harm? And the rule, again, I emphasize the rule because there are some people who say there is a principle of proportionality, which is broader in scope. It applies to all military operations, and incidental harm is broader. It's not limited to those identified in Additional Protocol 1. People claim this. I would love to be able to agree to them, but there hasn't really been much unpacking of this principle of proportionality. So if we stick with the rule, which is what Additional Protocol 1 refers to, it is just 3 types of incidental harm that we need to look at: the death of civilians, injury to civilians, and damage to civilian objects. And we entered into these different elements in the report in a number of areas. So the report focuses on some of the open questions relating to these types of harm. Open because different views have been expressed, or perhaps just because they haven't been explored. So one particular unexplored question, not contested among the experts, is the question of whether the nationality of civilians or the party under whose control they find themselves, is that relevant? Now, the question of nationality we dismissed very quickly because Additional Protocol 1 really abandons any notions of nationality for the rules on the protection of civilians that existed in the Geneva Conventions. And the question of under whose control the civilians are is similarly irrelevant. The rule of proportionality doesn't focus on the question on who has control of the civilians. The incidental harm to be considered is the death of injury of all civilians, both those under the control of the enemy who might be harmed by an attack, but also those under the belligerent, the attacker's own control, including its own nationals. And this is something that was recently addressed by the Syria Commission of Inquiry that looked at an attack against a water spring. And in assessing that the attack violated the principle of proportionality, it looked at the impact of the damage of this water spring, so therefore lack of access to water, both for the civilians under the opposition's control, but also to the civilians under the control of the government of Syria. And I think this is, people say obviously it does, but this is actually an important point. And we had a lovely Norwegian, a phenomenal Norwegian military expert among us who was saying, during the occupation of Norway was willing to tolerate a higher level of harm to its own civilians, which might have been true during the Second World War, but that's not something that is acceptable in the rule today. There is no notion of accepting harm to your own civilians. That's not how it works. Harm to your own civilians must also be considered in this balancing act. So that's just one open question when it comes to whose civilians, which civilians must be considered. We also had significant discussions on the notion of harm, injury. So for example, does disease fall within the scope of it, or is it limited to injury? And under medically there is a distinction between injury, which is something caused by external forces, and diseases. But we said, look, the term injury is used in 77, but there is no reason to exclude a disease. Otherwise we would come to these completely counterintuitive positions where, if we talk about, for example, a nuclear weapon, the damage caused by the kinetic force of the nuclear weapon would be considered, but not the ensuing disease. So obviously it should both be injury as understood in the narrower medical term, but also disease. We spent quite a lot of time discussing mental harm, and I always say his name wrong. Who's coming? Eliav? Eliav Liblich has written one of the most thorough articles to date on whether mental harm should also be considered. And I'll just spend a few minutes outlining why that is an issue. And there's two positions as to whether it should be included, yes or no. There's other rules of IHL that were developed at the same time as the prohibition on, as the rule on proportionality in the additional protocol, that prohibit the intentional infliction of certain types of mental harms. What are these? We've got the prohibition on acts or threats of violence whose primary purpose is to spread terror, so purely mental harm, among the civilian population. There's a prohibition of mental terror and to mental well-being. These prohibitions are set out in the additional protocols. Should the fact that the provisions expressly referring to mental harm are to be found in the same instrument as the rule on proportionality, and the fact that the rule on proportionality does not mention mental harm, should we interpret this as saying that the drafters intentionally excluded mental harm from the scope of the incidental harm to be considered? Probably not. The fact is merely a reflection that at the time it was not considered that attacks could also cause mental harm. And we were lucky to have one of the participants in the negotiations of the additional protocols among us, in our discussions, who said, no, we just simply did not consider mental harm. It didn't enter our thinking that it could also be one of the consequences of an attack. So on the basis of this, we said there is really no reason in principle to exclude mental harm from the scope of proportionality assessments. However, the nature of mental harms raises a number of practical challenges to key elements of proportionality assessments. And this is where the problem is, including questions of causation, of foreseeability, and some say of the weight to be assigned to the risk of occurrence of mental harm. So if we look at these a bit more closely in terms of causation, the rule of proportionality requires identification of the harm expected as a result of a specific attack. And while it's usually straightforward to determine whether physical injury has been caused by a specific attack, it is far more difficult to do so with regard to mental harm. Civilians are frequently exposed to hostilities for prolonged periods of time, making it very difficult to determine whether it was this particular attack which caused the mental harm. But that is what the principle of proportionality requires us to do. If we look at foreseeability, the occurrence of mental harm is far more subjective than physical harm, which makes it much more difficult to foresee. So the effects...
When we talk about mental harm and physical, aren't these the same in mutually exclusive. I mean, it's part of the same thing.
Well,
So
that's
why we should divide and give assessment?
just because I agree. I mean, this is what the
Suppose
legal.
I got injured, so I lost my one hand. Suppose.
Yes.
So that has a different mental thing for me, and for others it.
You're right, and I think, I mean, that very clear example is an instance where you have suffered both physical harm, and that has led to mental harm. And there might be instances in which you haven't suffered physical harm, but you've also suffered
So is
mental
it like
harm.
mental trauma or something,
Yes,
which lasts for
exactly.
your
long.
life, or is it like temporary?
Well, these are all the challenges. These are all the challenges intrinsic to mental harm. And if you want, it's easier if you've also suffered lost a limb. It's much harder if there isn't that dimension. And it's precisely because of these very practical challenges of both determining causation, foreseeability, quantifying it, that has led to those involved in conducting proportionality assessments to bulk and say, how can I actually take this into account? And that was very much what the military experts around the table said. They were divided. They all agreed that they weren't taking it into account at present. They were saying it's not something that we actually factor into, but they were divided as to the reasons for it, as to whether it was because the law does not require them to do so, or just because they do not know how to do so yet. So that's a bit where we were at the end of the discussions, and I think on the whole there was agreement there's no reason to exclude it in principle, but at the present moment it is very difficult to find ways of actually including it in the assessment. I think possibly too much emphasis has been laid on the outside to suggestions that military harm alone, mental harm alone could render an attack disproportionate. That's not where we're at. We're at a situation where we're saying, at best, mental harm is one of the factors that you should also include when carrying out your assessments. So that's where we're at in mental harm. We also spent considerable time discussing the natural environment and dual use objects, but I'm going to stop now, I think, if that's okay. And then if you really want to hear about the environment or dual use objects, I'm happy to discuss with you.
This is where we open the discussion to the table. Any questions? No order, just raise your hand and let Manu see your hand. Do you want to collect questions, or do you want to one by one?
I think my friends have got questions.
Let's see if some of your non-friends also have questions.
Sorry.
Fine.
Okay.
Because you have a tendency to draw to your friends immediately. Just make sure.
No, but she
Everyone's my
expands
old
her
friends.
circle of friends very quickly.
Very quickly, yeah.
So
everyone.
do you want to take everyone's names? Do you want to take everyone's name? You're sharing. So I'll take a set of questions.
We'll
take a few sets.
Yeah, we'll take a couple of questions
Yeah.
and then you answer.
Okay,
so
you've
who has
seen
a
it.
question? I've seen Yali, Ziv, Eli.
You've had a question. Did you? Yeah, no, that's fine. No.
So Yali, Ziv, Eli, Nico, and then Robert. And we stop after 3 and then have 3 more.
Okay.
So
Yali.
Nico, Robert, and the second part.
Yeah. I have lots of questions I'll ask later. I limit myself to just as I'll start with the first question. What was your methodology? What was your aim to understand what's the current, what's the lex lata or the lega ferenda? Did you try to find out what is currently customary international law or the interpretation? So this is the first question, and the second question. So I'm not asking about the specifics, but on the broader implications of the study. As I see it, the main problem with proportionality is that it has zero effectiveness. The obligation, right? We don't find many cases in which a court found, right, a violation of the principle of proportionality and so on. And my question is, how does this study, right? Is it easier now to find violations of the principle of proportionality? And in this regard, you've mentioned the last part of the report when you specify the procedure. So are you going in the direction of those who emphasize precautions in attack and these types of procedural getaways from the actual substantive assessment of proportionality?
First of all, thank you, Manuel. I'm a great admirer. I just want to, before I comment to you, I want to say to Yali, the fact that it's not enforced by criminal law does not mean it does not have an effect. It's a conduct rule that affects behavior.
We assume that it affects behavior, yeah, but
Ask military personnel; they would say rather strongly that yes. One terminological question that a substantive issue is hiding behind, and that is when you're saying not every operation is an attack. So I would say not every military action is an attack because there's a connection between the term operation and the use in bello proportionality rule. If you look historically, it developed in correlation with the operational doctrine, which created the levels of war military doctrine, which means that you have the tactical level, that the highest tactical level is the battle. You have the operational level, which addresses operations, and you have the strategic level, which addresses campaigns. So several battles are an operation, several operations are a campaign, several campaigns are a war. And the tactical level and the strategical level are old. The operational level has developed gradually over the last 150 years in correlation with the development of the customary rule of use in bello proportionality. Meaning, if you look at the terminology of the treaty and even before, the idea was that the operational commander, the person that is making operational decisions, is the one that needs to do the lowest level of the use in bello proportionality assessment. So I would say today, because even in armies, the operational decision making has gone down the chain of command, it would probably be the battle as a whole, where you make the operational decision. And again, it varies between one military activity to the other, but when you're saying that you want to talk to the military personnel, if you talk at the terminology of the levels of war doctrine, that's something they understand, that's something they learn from early on, and historically there's a correlation between the development of the legal role and the development of that military doctrine.
Two short points. First, you emphasize that the whole discussion is in context of attack, and of course we have to remember that proportionality comes from other directions, other bodies of laws, both domestic and international as well, international human rights law. So you can extend your analysis also to events which are not attack in a narrow sense, but the norms come either from internal constitutional doctrine or external human rights law. Even violation of basic civil rights are also subject to in international law to proportionality. So I think that this limitation is true when you talk about the specific field, but not when you talk about the actual behavior. Second, more serious challenge is the challenge of how do you really take into account legitimate benefits from an attack. And the question here relates to time span. It's a very similar discussion of the criticism of any efficiency or utilitarian maximization exercise. the military commander says, we can take two kind of operations. One, which will bring us to 10 days of 2 weeks of quietness. The second, which will bring us to 3 months or a year of so how, and of course you can extend it, if we give a very major hit, this will create silence or a peaceful situation for a year. So how do you take into account this time calculation in this cost-benefit analysis of proportionality?
Now you answer.
Thank you. Excellent questions, and please, everyone chip in, because I'm particularly those who are much more familiar than I am with the military side. Thank you very much, Yali. In terms of methodology, what we wanted to do was determine what the law is at the moment. We intentionally did not want to determine what was customary. Luckily for us, the ICRC Customary Law Study very conveniently said that the rule as formulated in Additional Protocol 1 reflects customary law in both international and non-international armed conflict. So we said, thank you, that's what we're going to base ourselves on, and what we're going to try and do is look at areas where the law is unclear, perhaps, where this framework as law is unclear. I'm going to be very honest, when I started off, I said, oh, no one's looked at general public international law. I'm sure it's got a ton to say about causation and about causation principally. And then when I actually started doing that research, I realized there is virtually nothing there. It was really disappointing. And I said, look, we had a discussion with them, with the editors, and I said, look, I really want to say that I've looked at public international law and there's nothing there, because otherwise the next person who looks at this says, oh, well, you haven't looked at public international law. And in fact, there's so little on causation there, it's quite amazing. So that's a bit one element of methodology. In terms of what we looked at a lot of military manuals in several languages. We had the fortune of a number of IHL clinics helping us, so we had a good language spread. But for the most part, military manuals just repeat the rule. And then I realized, if I really want to get somewhere, I've got to look at doctrine. So I managed to look at the doctrine of a few states that have it public, so that it's probably self-evident to you. It was a discovery to me as going, that's where I'm going to find my answers, but it's far more difficult to get them. Zero effectiveness. Well, thank you very much, Ziv, for that. And I have to say, but I completely agree with you. There's been virtually no jurisprudence, and then when you actually look at the rule more closely, you say, and I completely understand why there is no jurisprudence, criminal jurisprudence. It is just so difficult to determine, not so much to determine what falls within the two sides, even though at the end of this exercise I said, look, I've gone through the motions as a good civilian of determining what falls in and what falls outside. I wish the military would also attempt to set parameters far more clearly, because they're quite fuzzy when you ask them, come on, tell me what military advantage is. And I don't know whether they're fuzzy because they want to not set limits, or just because it is intrinsically more fluid. So completely agree with you. There's been very limited criminal case law for this, and I'm not surprised. I just think individual accountability is not the way to take this forward. You're not going to promote compliance that way. But as Ziv pointed out, it really does affect the way parties behave. It is a core rule in regulating their behavior. And I hope that this study was useful in making suggestions as to the type of information they need to look at. And then, yes, precautions do play a very clear role, because it is at that stage of the process that you set up all the elements that are necessary to comply with the rule in practice. So I have to say thank you for those two questions, because those I could actually answer. Ziv, thank you very, very much. And as you were speaking, I wasn't sure whether your answer went to the question of what constitutes the attack as a whole, as the unit through which proportionality needs to be assessed, or whether it it went to a different question, which is the distinction drawn within Additional Protocol 1 between military operations, which I'm still without connectivity, so I couldn't check my my Geneva my additional protocols, but I think it's Article 51 that refers to military operations more generally, and then the rule on proportionality focuses on attack. So I didn't know whether your comments went to one, to the other, or to both.
So my comment went to you said that it was an issue of customary international law and of terminological as well as addressing military personnel. What is an attack would always be fuzzy, because even an attack in its legal sense is part of a greater campaign. But the same fuzziness as a matter of practice also exists in another field, which is military doctrine, when they address the levels of war. So it's a matter of terminology. There's a parallel between the two. The parallel is not coincidental. The parallel is due to the fact that the idea of an operation, of operational decision making, has developed once line fighting has disappeared, and you suddenly had not only tactical fighting and tactical decision making and strategic decision making. And when that happened, the use in value proportionality has begun to develop. So I argue, as a matter of customary international law as well, that is the level it was intended and it's supposed to apply. So I agree that it doesn't solve all the fuzziness, but I think that as a legal matter, that is where it should apply, and as a matter of addressing military personnel, it makes it much more identifiable for them and understandable for them where to put it once we recognize that it's going to be fuzzy anyway.
Yes, but it's going to be fuzzy, but we still need to determine for the proper application what constitutes an attack as a whole. And I wonder whether, do you use the word operation in the same way as an attack as a whole?
I'm using operation as it is used when you open now the U.S. Army military doctrine manual. When they'll define operation, I'll say that is where the proportional using value proportionality decision making should be made.
Operation Protective Edge.
No, but you do not.
No.
But exactly, you do not do that.
But
That's
inside
not right.
Operation Protective Edge, you have different fragments in which operational decision making has already been made. So arguably, it would be already from what is beyond the battle, a lone battle.
I'm looking for a blackboard because I think it would be really helpful to break it down. And as a matter of law, I think it is important both to determine what's the attack as a whole and what's the difference between an attack and a military operation. What forms part of a military operation that isn't actually an attack, because there's different rules. But that's a separate conversation. Ellie, thank you so much. Your first question I can answer. I can attempt to answer, and I completely agree with you that there's other forms of proportionality that are also relevant in different ways. I'm thinking Eliav, am I getting his name? Eliav. He looks at how you said bellum concept of proportionality, regulating resort to use of force, if and how that continues to apply during the conduct of hostilities. Is it relevant just to determine whether resort to force in response to an armed attack is allowed under Article 51, or does it continue to apply, and if so, how, in parallel to this different notion of proportionality? And I think that's a very interesting conversation to have, and I think it goes very much to your question, to your point, I think. I think human rights proportionality, when it comes to the use of force, is slightly different. It is use of excessive force beyond what is necessary, strictly necessary to meet a legitimate objective. And I think there we need to be a bit more careful in applying, it goes to the interplay between IHL and human rights law. I would feel quite uncomfortable applying the human rights standard of proportionality when looking at an attack in the conduct of hostilities. I would say that's one of those instances when it is IHL that's the primary body. With regard to your legitimate benefits and the time span, I think it goes to the conversation we're having about the attack as a whole, and what I was trying to say in terms of when you're looking at your military advantage, which I think is what you were saying, if the military advantage is longer term, then we should use the similar framework for also determining the incidental harm. We shouldn't just cut off the incident, as some people suggest. They say, oh, the incidental harm is that which occurs immediately upon the attack or maybe a couple of days afterwards. There's no reason for limiting it that way, all the more so if a longer term is taken for the military advantage. But I also think it ties into the question of what is the unit, what is our framework, what is the attack? Are we talking about a particular attack, or are we looking at the operation, Operation Protective Edge? And I'd say that's not really within the framework of proportionality. Protective Edge is not my unit of analysis for proportionality.
Yumiko?
Well, it was very interesting topic, and I'm just wondering what's the youth and the relation with youth and the principle of the. You said that you have more thought about the environment and youth. No?
Dual use.
Yeah.
Yes.
Sorry.
Oh, yes. Well, that's.
Sorry, I didn't want to open up the other
Yes.
discussion.
No. Ido, how are we doing on time?
We have 10 minutes.
Okay.
Okay.
So the environment. Ido.
Can I take one more question?
And I wanted to ask
After Yumiko, we have Anna, Robert, and Elad, so it's going to be a few short ones.
Okay.
Short
So
ones.
later, maybe I'm gonna.
Sure. I'll give you the easy one.
But Manu is here until Thursday, so you have more than one chance to
You-
tackle her.
You can have a question if you tell me your name again.
Elad.
Elad.
Yeah, Eli.
What's Elad? What's your question?
Oh, sorry. That you're collecting. So, first of all, thank you very much. That's very, very interesting. I was listening to you describing this rule, this formula, with in an attempt to almost create a mathematical precision to the parameters, and it sounds admirable, but a bit hopeless maybe, because the point of view of the rule is the point of view of the military commander, the reasonable military commander. And going back to recent examples, it seems almost impossible for an outside observer to say with authority this attack was disproportionate. Of course, one example is in the end of the recent Gaza war, Israel used massive force to prevent the capture of an Israeli soldier. And for an outside observer to really assess what was the military advantage in this operation, and then say with authority this and this was disproportionate, again with mathematical precision, sounds to me almost impossible, or impossible in practice. And perhaps we should be moving to a place where we acknowledge that proportionality is not so much something that you can create an accurate formula, but a space of military discretion. We can say what is definitely disproportionate in the outside of this space, but within this space, just leave the burden off proportionality, because it cannot help us in that space, and try to use some other procedural or more or other precautionary rules that will help to minimize harm to civilians. And one quick methodological comment maybe. You talked about a lot what the drafters intent and whether they want to do this or want to do that. And I think that because the rule is considered today to reflect customary international law, and in some of the actors, it is only customary international because they're not part of the first protocol. It might be also useful to look at historical practice and not just text and the subjective intent of the drafters.
Thank you very much for the presentation. What I wanted to ask you is, what about the risk to one's own forces, the risk to one's own side, and how, and if you think that this is something, is a factor that should weigh in, not only when talking about civilian harm in the context of the so-called proportionality principle or rule, or when assessing even the very relevance of the rule, because I find it problematic to talk about civilian harm in the context of proportionality as if the law allows or encourages, in a way, civilian harm. And my question is, and my understanding is about the principle or rule of proportionality, that it goes deeper, and what is relevant is the factual and normative parameters within which the law is embedded. So I would very much like to hear your thoughts about this.
So many comments and things to ask, so we'll try to focus on some of them. First of all, thank you for a very good work. It's a very good report. I think it's important. It takes things to the analytical level, trying to say how to work with the principle of proportionality. The problem again is the question of implementation, and here the case law, and I've looked at the case law that you were looking at, is missing. One thing, little contribution I can give you, it's another case, Israeli case law, the case of the killing of Salah Shehadeh. Salah Shehadeh was the head of the military wing of the Hamas. He was targeted, killing with him, unfortunately, 14 civilians, 11 of which were kids in the just buildings, surroundings. It came to a petition to the Supreme Court, and then there was a committee, an external committee examining this case. The interesting thing is that the committee found out that all the commanders that went to the committee said that if they knew that was the price, they wouldn't attack in this case. And the committee took it as it was disproportionate, that the killing of 14 civilians in this case would be disproportionate. But this is the problem with proportion. I'm not sure that the committee was right on that. Okay, so because if you ask each person here in the room what is the how many people could die with the head of the military wing of Hamas, you'll get different answers. And it's not that commanders, there was saying here that what the military commanders think about it. Military commanders are very, they think of proportionality all the time. In fact, they think that IHL is proportionality. That's the whole issue, that's the whole idea of IHL. It's a very problematic issue. So. But the one thing that I have problems with is, would be not surprised, the issue of mental harm. If you say that if you ask what law is at the moment, if that's what guides you, I'm not sure this is law at this moment. In the recommendation to make ways to understand what mental harm, to assess mental harm, it's something which is a bit problematic, because I'm not sure doctors will know to do that, and let alone army planners or doctors that you will consult with. It has a very, because of the things that you even write there's a question of causation, foreseeability, and weight. You're absolutely right, and on that, and I'm not sure there's a way to bridge this problem, which is and this another problem that will result from all this is the problem of clarity in the law. IHL is something that should be a tool for. This is what we want it to be, a tool for commanders to work with, and the impossibility to assess what would be the mental harm in every case would be very it will pose almost impossible restrictions of implementing or those who are trying to implement IHL, which would be a problem. It's a burden that it falls again on the side that is trying to obey the law on that. Having said that, there's a question, if you have the time, answer maybe later. How do you see proportionality under 23G in The Hague? Contrary, when you how does it go with API proportionality, API 1, the protocol?
Yeah.
Is it the same proportionality when you destroy a civilian enemy object under 23G, or as a proportionality under 51, 57?
So here's your challenge.
Right.
One sentence each.
One sentence each. We'll speak later. We'll speak later, and I think dual use is more interesting than environmental harm in that regard. It's going to be more than one sentence. I completely agree with you, and we actually note almost verbatim some of your points. It's not something that you can conduct with mathematical precision. It's just not that kind of exercise. There isn't an app that will tell you proportionate or disproportionate, provided the steps are taken. And it really comes back to the value of the principle of proportionality in terms of procedures that belligerents have in place. And I really think that is the value of the rule, and that's where we hope to have contributed, giving commanders, reasonable commanders, all the necessary tools at their disposals, those that the law and precautions require, in order to make a reasonable decision in good faith. I completely agree with you. I also completely agree with you that it is extremely difficult for outside observers to say that the rule has been violated completely. And that's what I kept on saying when I was at Ocha. I was going, just stop saying it's disproportionate. Even if you've got rid of those graphics, we just simply do not know what the military advantage is. Don't emphasize concerns, say it's unacceptable, look at precautions. It's very difficult for outsiders to do. Again, I emphasize that does not mean the law has no value. It's just difficult to assess from the outside, but there are clear responsibilities of steps to take internally. I've got a big no with regard to something you've said, and I think is maybe you said that it's that we should. I don't think we should take the burden off proportionality. I think it plays a very fundamental role. We just need to know how to use it, how to invoke it, and the focus is on precautions, including in terms of the precautions that parties must take in order to be able to comply with the principle of proportionality. Drafter's intent. I only mention drafter's intent when it comes to mental harm. Oh. Okay? Practice, that's interesting because, and it ties in with what you were telling me about the cases. Now, for some reason, I know I had that case and then I didn't include it. There was a reason why, and it could be because we only included cases that looked at the notion of excessive, and for some reason that wasn't relevant. I'm going to look at it again.
The Hebrew version maybe will be more clarified. The committee were sure about it. They're saying that it was disproportionate.
Yes. So why did I not include it? Because I know I had it. It was what we did in order to determine what's excessive, because we didn't discuss it today, but determining what's excessive is extremely difficult and there's no guidance. So what we did is we went out to the states that we were engaging with and said, can you give us examples from your training manuals, from actual real life operations when you determined something was or wasn't excessive, and we got nothing back for a range of reasons. Occasionally they said, look, it's confidential information, we can't give it to you. For the most part, the states that were involved in our consultations tended to operate through coalitions. And what coalitions have frequently done recently is to set themselves higher standards, so a lower tolerance for incidental harm as a matter of policy. So they said, look, the examples we would give you are not actually reflective of the law, of what we think the law is, but rather of where the standards, the more exacting standards we have set ourselves as a matter of policy. So, Robert, I think we agree, I mean, that criminal isn't the way to go on this, but you said the challenge is implementation, and I think there's many steps that parties can take to implement their obligations to comply with the rules, so to integrate it in their internal systems. It's the external oversight that's challenging, I think. In terms of mental harm, and I have to say that and dual use are the two areas where we had an environment, to a point, the greatest divergence of views among the experts. And we're not, again, to be clear, this does not reflect the unanimous view of all the experts.
This is why you're the only one that's signed on the...
I'm the author.
Really?
I'm the author. So it's not one of these reports, I can't think of one that actually reflects the views of all the experts. It's one of those. It doesn't necessarily reflect the views of all the experts, and I would say that, as I said, mental harm is the one where there was most discomfort, precisely for the reasons that we identified, just the very practical challenges. That said, there was some state practice. There were some states, and there were NATO manuals saying it's something that should be taken into account. So it's not that it was just Manu thinking this. We did have some state practice, but I agree with you in terms of the challenges.
My question is, it goes to the recommendation that you have, whether it's feasible, whether it's something that even can be done, because again, even doctors will have a very psychologists and psychiatrists will have problems to identify where are the cases or when,
Yes.
let alone during battle. It's something that
Yep.
that's the problem. The question is whether this recommendation is something
Is even
that
feasible.
is even feasible at this time. Maybe a
Yep.
decade from now, 2 decades from now, it will be something that may be more easily evaluated.
Yeah. And I thought we had included words in terms of
4.5.
medical knowledge evolves. Just one point on mental harm. It's got to reach the threshold of amounting to an injury.
Of course.
Of course,
There's
I know
there's
Yeah, I
no
agree
problem
with
with this. It's not
no,
an
I
issue,
agree with
clearly,
you.
okay.
Yeah, I agree with you, but let's just emphasize that. It's not, as someone said, New York mental harm.
No.
It's injury.
Oh. Thank you very much, Manu.
Sorry, your normative question. Sorry,
Yeah.
risk to one's own side is military advantage. I'm really sorry, Anna. Is military advantage. It's part of the military advantage.
So you think that it should weigh in as a factor there?
It's part of the military advantage, definitely. The extent to which it weighs is what's under dispute. And then I was smiling at the factually normative, what were your terms? Relevance. Yes.
Yeah.
Passing, if my
So
military...
even
Okay.
so you would
Outside,
We have
we're
to-
out.
We still have a very long. This is the first presentation out of 2 weeks, so at some point we need to cut it short. Thank you, Manu, and we're going to take 10 minutes break and regroup.
It